Hi folks, this is attorney Kip from Malek and Malek. In this video again, one thing that comes up one thing that I always warn people about when they get injured, particularly if you're working at like an L Brands or Cardinal Health or Amazon warehouse, one of these kind of massive corporations, and it could be a small business too, but when you get injured, you need to seek medical treatment and either urgent care, ER, your primary care physician, workers' comp doctor, whatever. And so you get your thing initially recognized for that. And when you go there to the ER, urgent care, or your primary care physician, they might give you like a work excuse slip. And if you look at this, it's probably going to be for 2 or 3 days. What's really important is that during this, because what you may very well 100% have a workers' comp claim, but your employer may not know about the claim, or the corporate aspects of your employer, the HR aspects of your employer may not know about your claim. And so while your claim is pending, if you cannot work, you absolutely 100% need to be in contact with your employer every day that you're scheduled to work. So if you cannot work due to your work injury, you physically cannot work, you need to call your employer, your HR, your supervisor, your manager, basically everyone, frankly. You can't be too cautious in this endeavor, and then you email, call, and fax if you can. But you want to let them know, hey, I'm not coming into work today, I'm taking a sick day, I'm still having problems due to my work injury. But what you absolutely 100% don't want to do is you don't want to assume anything. You don't want to assume that people understand that you have a work injury, and that's the reason why you're not at work. So, and again, don't assume that people know what's going on. Don't assume that people understand what's happening, because a lot of times, and because what happens is, somebody gets injured, they don't show up for a week, and then they're terminated. And because they violated the no call, no show policy, and the no call, no show policy is about, you get about 3 no call, no shows, and boom, you're terminated. So until your physician of record, your BWC doctor, takes you off to work and the employer 100% understands that, and that you have the Medco certifying you off work, do not show up at work, or do not call in and get that work excuse. And the other thing is, let's say you've gotten your work injury, and your work excuses run out, so you go back to work and you keep on working, but your pain and the limitations of your work injury are such that you cannot continue to work. Don't just leave. You want to tell your HR, supervisor, manager, etc., hey, the pain and the limitations due to my work injury that I had on such and such date are such that they're really problematic for me right now. I can't continue working. I'm going to take the rest of the day off as a sick day, and I'm going to go seek medical treatment. And then you're going to go to your, again, HR, ER, urgent care, your PCP, physician of record if you have it, your BWC doctor, and then you're going to have them take you off to work. And that's always what you're going to do anytime you're at work and you cannot work. You cannot unilaterally take yourself off work. You have to be taken off by a doctor. So, but what you need to do before that is you need to let your HR, supervisor, manager, etc. know, hey, I'm taking a sick day, I'm getting treatment. Get that treatment, and then get your stuff undertaken. And then it'd be good if you had a BWC doctor, because then they could certify you off work. The other thing is, let's say you have a work injury and you have a BWC doctor and they release you to work with restrictions, and your employer has accommodated work duty for you, and so they have this accommodated work duty, but it's I don't know, you're having a hard time doing it, okay? The accommodated work that they have for you is problematic, And so, but again, what you need to do is you need to reach out to your BWC, POR, your physician record, and you need to say, hey, I tried to do what's in the restrictions and I can't. Or the alternative is, I have these work restrictions, my employer's not accommodating them. Could you please give my job a call? And a lot of times the occupational medicine, your BWC doctor, your occupational medicine doctor will have no problem calling up the employer and explaining, hey, this is what this Medco says, and this is what they need to be doing. This is what I understand that you're doing, or tell me what you have this person doing, and I could tell you if this fits within their accommodated, work that you have for them, or if it fits within the restrictions that I've given this person. And if it doesn't, then the doctor might say, okay, you're not adhering to these restrictions. If you don't, I'm gonna go ahead and write this person off work. Or alternatively, if they are, the doctor might say, okay, my patient's having problems doing these. I'm gonna have to give you new restrictions, and we'll see if you can accommodate these restrictions if they have them working and they're having problems if they have them walking around, standing, and they're having problems with that. The doctor might say, do you guys have sedentary work? Because I'd like this person to continue working. Is that something we could do? Because I'm going to write this Medco with the sedentary work restrictions. It'd be cool if you guys can accommodate that. But if not, again, I'm going to write that to them. But the understanding, what you're telling me is you're not going to be able to accommodate them, and therefore, I'm going to recommend that frankly, if the employer can't accommodate those work restrictions, and the injured worker can recover temporary total during that time. But bottom line is, never unilaterally do things, and then never assume that, one, your employer is looking out for your best interest, and then two, that people understand what the state of your claim is, or what your injury is, or what needs to be happening. You absolutely 100% have to be your best advocate, and you need to let your workers' comp doctor know what's going on. You need to let your workers' comp attorney know what's going on, so that they can help you, in that endeavor. But if you don't let people know and you assume things, that's when people get terminated. And then we go back to that 412356F. If you get fired for that no call, no show, that you don't call in 3 times, or you don't show up 3 times, there's this 3 statements, or the 2 statements rather. The first statement is, are you working for reasons, or are you not working for reasons related to the impairments of your workers' comp claim, or are you not working for reasons directly unrelated? And so they're going to interpret, the IC and the BWC probably are going to interpret your request for comp on that second. They're going to say the person is not working for reasons directly unrelated to the work injury, i.e., and you're going to say, well, I didn't show up for work and I didn't call because I didn't know I had to. And what they're going to say, well, you signed this employee manual, correct? That's your signature right there, and it's dated, whatever it's dated. And you go, well, yeah, but I didn't read it. And they're going, well, you're supposed to read it. If you turn to page 4, it says if you violate the no call, no show policy, if you have more than 3 violations, you're terminated. And that's what happened. So you're going to be bounced, and that's going to be a problem, because it's going to not be pleasant when you're not able to work, and you're not getting workers' comp, and you're completely not able to work. You're not getting workers' comp because possibly you could apply for unemployment if you had restrictions, but if you're completely taken off work, then you wouldn't even be able to apply for unemployment. You'd be in a bind. So with that being said, you've been listening to Attorney Kip from Malek and Malek. Questions, concerns, comments, let me know. Email me, call the office. If you have a work injury, if you've just had one, or you've had one going for a while, and you have questions, concerns, give us a call. We'll try to answer your questions to the extent that we can. If we think you need representation, we're going to let you know. If we think you don't need representation, we'll let you know as well. And the other thing is, there's no obligation to sign up with us. So you could pick our brains, you could mine our knowledge, And you could take what we say and go with another law firm. That's fine. There's a lot of great workers' comp attorneys in Ohio. So honestly, if you go with us, that's awesome. But if you want to go with somebody else, that's perfectly fine as well. I just want you as an individual to get the best outcome that you can. So with that being said, thanks for listening to this. Have a nice day and good luck.